fulfilled than a company in private contracts. But forget everything. Let us see, my lord, what the Act says.
Yes, whether, let's read. We'll read the provision of the Act and see how you're reading.
Yes, my lord. And whether if the Act does not prohibit, alternatively, if the Act permits one party to have a clause regarding there being a panel, which right now, my lord, there is doubt whether it is permissible or not.
So
whether the Act permits. Please come to page section 4. Section 4. Section 4. I'll invite your lordship's attention to only relevant clauses, my lord, just to which assess the court, my lord, in this particular question. Section 4, your lordships have, my lord. I'll read. A party who knows I'm sorry, can I read, my lord, if you lord? A party who knows that A, any provision of this part from which the parties may derogate, or any requirement under this under the arbitration agreement has not been complied with, and yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period, shall be deemed to have waived his right to so object. My lord, the meaning, as I have understood, is that party, if it is clear that some provision is derogable, but agrees to it, or there is some requirement in the arbitration agreement, but permits it to be waived, if I may use, my lord, my expression, then it is prevented, meaning thereby
There is the estoppel principle.
correct, meaning thereby
Estoppel, because
estoppel, you're right.
Principle of estoppel not against a statute will not apply here. No estoppel will apply.
The statute operates as an estoppel. The statute says your conduct operates as estoppel. We don't have to borrow the.
Now, what do you think are the derogable provisions?
Pardon?
Which are the derogable provisions?
I'll come to that, my lord. Kindly, my lord.
Just bear that in mind. Later
I know, my lord. I'll have to answer that, my lord. My learned friend has says 34. I have something to say on that, my lord.
And then section 4. Then what is?
Section 4. Lord, this says party autonomy. You can have a provision, and by conduct, you can waive that provision, and thereafter don't object because you are stopped from objecting. That is section 4. Now, please see, my lord, the title of chapter 3, and this is, my lord, relevant. The title of chapter 3, which is section 10 onwards, is composition of arbitral tribunal. Your lordships are
going back to 4. 4 is in two parts. The first part deals with derogable provisions of the Act.
Yes, my lord.
The second deals with the arbitration agreement.
Correct.
A requirement of the arbitration agreement.
Yes.
If you don't raise it at the earliest possible opportunity, you are stopped thereafter. You
I'll just give an example what it means.
It's like the CPC says, objection as to place of suing or territorial jurisdiction. You don't raise a point of territorial jurisdiction at the earliest possible opportunity. You can't raise it later on.
Correct.
If it's otherwise a court of competent jurisdiction, you can't say that the suit was filed in Gurgaon instead of Delhi later.
Another example, my lord, what B means. My lord, your lordships have come across. Your lordships have come across several arbitration clauses. Generally, that arbitration will have to precede the conciliation. That there has to be a conciliation, and if it fails, then arbitration.
That's that clause B, requirement of the arbitration.
Exactly. So that suppose somebody straight away come to the arbitration, participates, then he cannot say that we have missed one.
Conciliation.
That's, my lord, so this is party autonomy. Nothing turns on the question in hand, my lord. Now,
like the MSME Act says, you must have conciliation and then arbitration.
Yes. No, even in several agreements, there is a provision for conciliation first, and then arbitration. Now, chapter 3, composition of the arbitral tribunal. This is the only chapter which provides how arbitral tribunal can be constituted. And as per the definition, sole arbitrator is also a tribunal, multi-member panel is also a tribunal.
Yes.
Now, my lord, 10 is not relevant, my lord, for either of us. Please come to 11. The way, my lord, I would respectfully read section 11. And if my learned friends are right, then we will make one provision at least nugatory. Provision in the chapter of composition of arbitral tribunal. And your lordships would also simultaneously find the party autonomy, a tailor-made, customized agreement is in contemplation of the parliament. Everywhere, my lord, in every section.
Procedure for arbitration.
Yes. Now, 11, my lord. A. 1. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Here comes party autonomy and the freedom to enter into a contract. This is relevant only to show that parties can agree. The contract is supreme. But second is most important question, important provision.
Procedure for appointing the arbiter.
Subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Lord, there can be an agreement which says that procedure will be as conventionally followed. I will select my arbitrator, other side will select his arbitrator, and both will request for someone to preside over. That can be one procedure. Another procedure can be you voluntarily enter into a contract which provides for an arbitration agreement which says that the procedure of appointment will be a panel of arbitrators. And you select one from the panel. Correct, my lord? Nothing prevents up to subsection 2 from parties in their act of volition agreeing into an agreement about the procedure for appointment.
Yes.
Now, this interpretation of subsection 2 gets further strengthened by subsection 3. Failing any agreement referred to in subsection 2. So, procedure of your choice, party's choice. If you cannot arrive at or the arbitration agreement is silent, failing any agreement referred to in subsection 2, in an arbitration with 3 arbitrators, each party shall appoint one arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator who shall act as the presiding arbitrator. So this is the second statutory option. First option is that you choose your method of constituting the tribunal.
So 3 is an exception to 2.
To 2. So other than this conventional method of one electing one selecting one, another selecting second, and they selecting presiding arbitrator is an exception if there is no other customized mode of arbitration tribunal constitution is provided for.
If parties have provided for a procedure for appointment,
Yes,
then that will govern.
that will govern.
So that shows that that procedure for appointment is a derogable provision. Isn't it?
Yes.
Subject to, it's a derogable provision. The very fact that he says that it's failing an agreement,
Correct.
show that once there's an agreement, that agreement prevails.
Yes. Not even one is derogable. That arbitrator can be
Even a sole arbitrator.
yes. arbitrator can be of any nationality is also derogable, that unless parties otherwise decide.
The only non-derogable provision is it shall not be an even number.
Yes, it can't be. It can't be. Then, my lord, 3A. The Supreme Court and the High Court shall have the power to designate arbitral institutions from time to time, which have been graded by the Council under Section 43(1) I for the purpose of act. My lord, I'm skipping the proviso. Please come to 4. Subsection 4. This may not assist your lordships. 3A will have no relevance for this question. Your lordships are on subsection 4, my lord?
Yes, 4.
4. If the appointment procedure in subsection 3 applies, meaning thereby no agreement. Subsection 3 is in absence of customized agreement. Then what? And if there is no such provision, 3 applies, then a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the 2 appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be. So if there is no customized, I'm using that expression, agreement, then 3. If 3 is also not present, then 4. Then kindly come to 5. Failing any agreement referred to in subsection 2. Your lordship has that, my lord. So there is no provision for a customized manner of constitution. In an app,
Just 4 or 5 minutes.
yes, my lord, your lordship may come after 10 minutes.
5 minutes.
I have some
Just 5 minutes. Just to stretch it. That's all. Yes, Mr. Chairman.
Wait, please. Lord, I was on subsection 5.
Yes.
Lord, your lordships would mark one thing, that 4 comes into play when 2 is absent. I hope, my lord, I am
Great, sir.
correct, my lord. 4 comes into play when 2 is absent. 2 is absent when there is no agreement between the parties providing for the procedure.
Yes.
Now, that is first 4 when there is no agreement, then 5, subsection 5. My lord, 5, yeah,
Yes.
I'm sorry, may I read 5?
Yes.
5, failing any agreement referred to in subsection 2. So no procedure prescribed. In an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of a request by one party from the other party to so agree, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4. The highlight, my lord, which I would respectfully make is that 4 and 5 would come into picture only when there is no procedure under subsection 2. Justice Narasimha, my lord, I am able to make 4 and 5 will come only when there is no 2.
Yes.
Now, 6. Where under an appointment procedure agreed upon by the parties, that is under subsection 2, a party fails to act as required under that procedure, or the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure, or a person, including an institution, fails to perform any function entrusted to him or it under that procedure. My lord, the procedure may stipulate. Just giving a hypothetical example, that in case of a dispute resulting into an arbitration, the arbitral tribunal would be constituted, say, by Delhi Arbitration Center. That can be, my lord, a possible, which is considered, my lord, under 6C. The appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be, to take necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. I'm sorry, my lords.
Yes.
Even 6 is derogable. Please see, my lord, 6, last line. If either of these 3 contingencies arise, namely, parties do not appoint, party appointed arbitrators do not appoint a presiding arbitrator, or if an institution is named in the agreement, the institution does not do anything, then the party will approach the High Court or the Supreme Court, but that is subject to last unless the agreement on the appointment procedure provides other means for securing the appointment. So even approaching the Supreme Court or the High Court is also a derogable provision by agreeing to it under an agreement made under 2. My lord, now, my lord, omit 7, it is omitted in 2019. Kindly come to 8. Your lordship has 8.
Yes.
The arbitral institution referred to in subsection 4, 5, and 6. Lord, 6, provided there is no contrary agreement. But let us take that there is an agreement. And either 4 or 5 or 6, the institution which your lordships have designated is approached. Before appointing an arbitrator shall seek a declaration, disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. Well, kindly pause here for a minute. The argument of Mr. Banerjee was that this part is non-derogable. I agree to that. I have a customized agreement under subsection 2. There is a failure and 4, 5 or 6 kicks in. 6 will kick in only, my lord, in case of 2. Correct, my lord? Am I clear? Subsection 6 will kick only when there is an agreement under subsection 2. But then 12 is non-derogable. You cannot appoint a disqualified person who is disqualified under section 12. I'll come to that, my lord. So, my lord, again reading, the arbitral institution referred to in subsection 4, 5, and 6. If we have 2, we are not concerned with 4 and 5. Before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to any qualifications required for the arbitrator by agreement of the parties and the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. But we are not concerned with A and B because their argument was that 8 is non-derogable, to which I have no difficulty. My right under subsection 2, my volition and their volition to enter into a contract with a customized arbitration procedure, customized procedure for appointment of arbitrator, will be not bound by section 12. I cannot disqualify anyone. I cannot make my manager an arbitral award. But giving an example, how 8 operates. There cannot be an agreement under subsection 2 which says that my managing director will be the arbitrator because that is prohibited under 12. 12 mandate will apply to my choice and their choice in entering into a contract under subsection 2. Now please come to 12, section 12. Rest will not assist your lordships either way. And my lord, whatever I am skipping, your lordships can take it, is not relevant for either of us. Lord, in such matters, we don't argue, my lord, to win a case or lose a case. We really assist the court. Hmm, 7. Lord, there are some provisions which came in 19, my learned friend Lord points out.
In fact, I was comparing it with your soft copy and then the hard copy because these are the post-19 provisions.
No, you relied. The institutional part of it is not. Lord, it does not make any difference to the interpretation. I think he agrees. Are you agreeing or not?
This section is technically not the correct provision.
So the correct provision of 8 is in footnote 2.
Correct. It is the Chief Justice, the High Court or the Supreme Court will.
Yes,
Chief Justice
we kindly
or the person or institution designated by him in appointing an arbitrator shall have due regard to any qualifications required of the arbitrator by the agreement of parties and any other considerations are likely to secure the appointment of an independent and impartial arbitrator.
My lord, the sum and substance of what my learned friend says, and I agree, is instead of institution, please read the Honorable Chief Justice. That's all, my lord. Nothing turns on the interpretation or the issue we are confronted with. Now, please come to, my lord, section 12. I'm sorry, my lord. My lord, the Chief Justice is somewhere, my lord, in some.
Of subsection 8 says other considerations
Yes.
as are likely to secure the appointment of an independent and impartial arbitrator.
When?
Therefore, the court has that duty to ensure that the person you are appointing is independent and impartial.
Yes. Correct, my lord. But that is even in abs. That's what I'm saying. Lord, only at the cost of repetition, let me say, Lord, even without this provision, the court has the duty to appoint an impartial and independent arbitrator. Nobody disputes that. But Lord, at the cost of repetition, Lord, please note this. 8 kicks in when 4, 5, 6 is present. And 4, 5, 6, 4 means no agreement under 2. 5 means no agreement under 2. 6 means there is an agreement, but you fail to act. So this does not touch upon the party's autonomy to enter into a contract providing for a specialized mechanism for appointment of arbitrator.
No, but even where the parties have provided for a procedure
Yes,
for the appointment of an arbitrator under 2,
correct.
thereafter, if you look at the provision prior to 2019,
Yes, Lord.
it says 6.
Lord,
Where
6.
the 6 prior to the amendment,
Yes, Lord.
where under an appointment procedure agreed upon by the parties. So we are now dealing with an agreed procedure.
Yes, but 6 is for that. Lord.
Right. A party fails to act as required under that procedure. Or the
Correct.
parties or the 2 arbitrators fail to reach an agreement expected of them.
Correct.
Or a person, including an institution, fails to perform. Party may request the Supreme Court, or as the case may be the High Court or any person or institution to take the necessary measure, unless you pointed out, unless the agreement on the appointment procedure provides other means other than going to the Supreme Court or the High Court or the institution.
Correct.
All right. Now, when 8 says,
Before that,
Yes.
my lord, kindly pause here for a minute on my request. My lord, 6 definitely would kick in. 6 necessarily presuppose an agreement under 2
under 2,
and non-compliance of what is stipulated under that agreement.
right?
Correct, my lord. Now kindly come to 8. The arbitral institution referred to in subsection.
Just read 8 from the soft copy, actually.
Yes.
Which is at 111.
Yes, sir. Where 8, your lordship.
8. The Supreme Court.
The Supreme Court, or as the case may be the High Court, or the person or institution designated by such court, before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 and 1 of section 12, and have due regard to A, any qualifications required for the arbitrator for the agreement of the parties. So your lordships, your lordship means the Supreme Court or the High Court will also be governed by the agreement under 2.
And B says the contents of the disclosure, and so the disclosure has to be made before you appoint the arbitrator.
Correct.
And other considerations, that's very important, and other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Correct, my lords.
This seems to suggest that even where parties have agreed to the procedure for the appointment of an arbitrator, but that procedure has not been implemented for a variety of reasons, you move the Supreme Court. Supreme Court is not bound, or the High Court is not bound by that procedure. That's the point.
No, no, my lord.
There are a line of 3 judgments of Justice Lora where under the agreement, there is an obligation to appoint an arbitrator, but one of the parties has not complied, so 11-6 come into the play. It was argued at that stage that now 11-6 has been filed, but when a court appoints, you must appoint according to the arbitration agreement. He has rejected that argument, saying, number one, that freedom no more exists because of non-compliance of you. Now the power and right exclusively rests in the court itself. And we will appoint, and when the court appoints, the procedure contemplated under 8A and B will apply. Those are the line of cases.
In case of non-compliance, we are concerned.
Right, obviously.
Issue arises only on non-compliance.
We are concerned whether two can have a particular procedure or not.
Of course, two can have a procedure.
But, my lord,
But if that procedure has failed and the matter comes to the court, then you are not bound by the rigors of the procedure which have been provided by the parties.
Well, certainly, but please read 8 again.
Because when the court appoints, there's an overarching duty of the court to protect independence and impartiality. And therefore, the court is not merely a rubber stamp to say, okay, I'll look at the agreement and I'll appoint the same person or the same people, however lack of independence or impartiality
Yes,
they may be.
no, that's not my argument also. I am not, my lord, pitching it that high, but please read it again. 8. My lord, what would be your lordship's consideration, the Supreme Court or the High Court's consideration? The Supreme Court, or as the case may be, High Court, or the person or institution designated by such court before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. So this is disqualification disclosure and due regard to. A. Any qualifications required for the arbitrator by the agreement of the parties. Suppose, my lord, agreement of the party says a chief engineer will be appointed. Then your lordships will have a regard to that.
That's because earlier set of cases said that even if court appoints, it must go by the agreement.
Yes.
That
is
got
1940
after
Act.
the amendment and the 2 judgments also.
Yes, 1940 Act. Those. Then, and second, the contents of the disclosure. My lord, disclosure means I come to
By the prospective arbitrator.
12. The disqualification. The contents of the disclosure and other considerations, which is, my lord, a wider, completely wide room, my lord, for the court, my lord. So apart from disclosure, your lordships can likely to, will appoint a person who is likely to be independent and impartial. So, my lord, sum and substances, there can be an agreement under 2, complete autonomy. If there is an agreement, but conditions not complied with, you come to 6. While exercising powers under 6, your lordships will examine 8.
But if there is no failure of the procedure, then parties are bound by what is envisaged in that procedure under 2.
And therefore,
That's
2, yes, brother, 2 does not prohibit parties to agree to a particular procedure which may include a procedure of selection from the panel.
Variably, 11 is filed on the ground that I've asked for arbitration, but they are appointing from the panel. So 11-6 is filed on that ground.
No, but they cannot, if they have agreed under...
Cannot, it's your argument.
That's my submission. Yes, yes. The lordships are right. So long as 12 is met. Now kindly come to section 12. Section 12 again is housed in the chapter titled Constitution of the Tribunal, Composition of the Tribunal. Am I with your lordships on section 12?
Yes.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any of the circumstances. My lord, he shall. This is non-derogable.
Yes.
So he must disclose, my lord, either approached by the party as per the procedure prescribed under section 11(2) or maybe by the Supreme Court or the High Court. A, such as the existence either direct or indirect of any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence and impartiality. Kindly see, my lord, the clauses, because this does not disqualify him. The only my lord, responsibility is to disclose. Then B. And B, my lord, I have a separate submission to make, my lord, for your lordship's kind consideration, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular his ability to complete the entire arbitration within a period of 12 months. This is what a prospective arbitrator is supposed to give. My lord, I'll come to that point. I'm not raising it right now, my lord, but this is a very, very vital point, my lord, which will go to the root of the issue. Then explanation 1. The grounds stated in the 5th schedule my lord, in ICC arbitrations, when an arbitrator is appointed, I'll show, my lord, when I come to that. Sorry. In ICC arbitrations, prospective is approached. My lord, in ICC, my lord, I'm not, my lord, I'm not arguing this right now. At the end, I'll say, but just as a by way of an information, in ICC arbitration, whenever a prospective arbitrator is approached, he is requested, there is a format that give me your calendar of 24 months henceforth. They decide whether he is able to devote sufficient time and whether the arbitrator would be able to complete it within a time period. I'll come to that, my lord, but that a little later. Now, my lord, 2. An arbitrator, subsection 2, from the time of his appointment and throughout the arbitral proceedings, shall, without delay, disclose to the parties in writing any circumstances referred to in subsection 1, unless they have already been informed of by him. Suppose some disqualification, not disqualification, some contingency under 12(1)(a) occurs during the arbitration. So he is supposed to disclose that. So throughout the liability of disclosure continues. Now 3, an arbitrator may be challenged only if A, circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Kindly pause it here for a moment. Lord, this is one of the grounds on which his appointment can be challenged. And if your lordships can now read it with explanation 1, appended to, my lord, immediately after B, subsection B. The grounds stated in fifth schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality. So this is to be connected with or read with 3A. 5A grounds are generally the guiding principles, but they are not, my lord, the exhaustive list. There can be other. My lord, one of my learned friends said that there is one arbitrator in the panel who always decides in favor of one party. Maybe that can be a ground, my lord, under 3A. That we have a reasonable ground that he is not neutral, he is not impartial, he is not independent. Then B, he does not possess the qualifications agreed to by the parties. Then 4, a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for the reasons of which he becomes aware after the appointment has been made. If he is already aware when the appointment was made, then waive. It is derogable. Then he cannot challenge, a stopper. You cannot challenge. Then 5. 5 is, my lord, non-derogable. Please see, your lordships have seen 12.1, mere disclosure, no consequence. Now 5, notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. This is the distinction between 1 and 5.
Yes.
So 1 is mere disclosure, 5 disqualification, he is ineligible. Lord, this will govern 11.2 also. There cannot be an arbitration clause which permits a person falling under 12.5 to become the arbitrator. That is non-derogable.
So Schedule 5 can be derogated from. Parties may say that, well, despite the fact that there may be justifiable doubts as to his impartiality and fairness, I still accept him. So,
I
but
will tell it.
7 schedule is ineligibility.
Yes, exactly.
Exactly.
I understand, but if I agree to 7, I necessarily agree to everything which is in 5 akin to 7.
Family arbitrator, suppose you.
There's a waiver, my lord. Family arbitrator, there's a waiver under 12.5 proviso. You can
12.5
waive, you can waive
Waive
it
afterward.
afterward. You can waive
After
it.
disputes have been carried.
And that's what the law commission says in paragraph 60, that in family arbitrations, you can waive it. That was one of the examples.
Right.
Yes, because it's always advisable that someone related is the arbitrator. No, please see the proviso.
This waiver under 12.5 proviso,
Yes,
it is subsequent to dispute. having-
Subsequent, yes,
They can
yes,
do that
yes,
at
yes.
that stage.
it cannot be at 11.2
It
stage.
not be at the stage.
And it has to
beginning.
be,
An express agreement in writing.
and it has to be an express agreement. in writing.
Express agreement. Yes.
I know that the arbitrator is my uncle, but we both agree to his arbitration.
Well, therefore, we are not concerned with such a scenario, but absent the proviso and the agreement contemplated, even in family arbitration, 7 would kick in. So, provided that parties may subsequent to the dispute having arisen between them, waive the applicability of this subsection by an express agreement in writing. So this is not, this is to be contrasted with other provisions where you can, by conduct, condone ineligibility or disqualification.
Is there any other provision which uses this expression, notwithstanding any prior agreement? Because this is the only provision, I think, which overrides an agreement.
This is subject to correction, but other provisions are subject to the agreement to the contrary.
Yes, it's the converse. So therefore,
This is
shows
notwithstanding,
importance.
more rigorous. Otherwise, possibly, the effect is same.
There's some commentary which I showed yesterday, which said that that list was not drawn up because you could make out wherever it is subject to the contrary, it is not mandatory, and where it is not, it is.
No,
was
that's my comment. I have something, I have some reservation. Commentaries, are ultimately views, but notwithstanding anything to the contrary, or at the end, subject to the contrary agreement, would have the same impact. But notwithstanding anything contrary to the agreement means the statute provides, prevails. Correct, Manoj? But statute is exempted by the provision by saying that except where parties agree otherwise. So they are converse situations. Yes. Now, Manoj, please see.
Section 5 provides for non-derogability in its substantive part, but that is relaxed by the proviso where there is an express agreement between the parties after the dispute has arisen.
Yes, Manoj.
Why after the dispute has arisen? Because parties are conscious of what is the nature of the contentious matter.
And the nature of this.
Understanding the contentious matter, they expressly agree in writing.
That my maternal uncle would have been.
Although he may be otherwise related, qualified.
Cannot be upfront before the dispute has arisen. You must be conscious of the dispute and then expressly agree it in writing.
And this is just, Manoj,
the exception.
academically for interpretation. Some of the provisions say that by conduct, you are deemed to have waived your objection. This is the provision where for 7th schedule, there has to be an express agreement, not merely by conduct or by inaction. By not objecting, you cannot waive. There has to be an express provision.
So the overriding of a prior agreement by subsection 5 is subject to the further exception carved out in the proviso.
Correct. Now, my lord, kindly see 14(1)(b). I'm just, my lord, saying that everything is party autonomy. You can contract whatever you want to contract. Because instead of a conventional litigation method, you are devising your own method of adjudication. Therefore, the entire act is replete with party autonomy, that you decide whatever you want to decide. Just as an example, 14(1)(b), the mandate of an arbitrator shall terminate and he shall be substituted if he withdraws from his office or the parties agree to the termination of his mandate. Parties can even enter into an agreement which says that now, henceforth, we are in the middle of arbitration, but we terminate your mandate. Everything is party autonomy driven. Then, my lord, please see next chapter, jurisdiction of tribunals. We are not concerned. I'm just, my lord, highlighting the my lord, heading of the chapter. 16 is competence of arbitral tribunal to rule on its jurisdiction. And 17 is, my lord, interim measures. My lord, we are not supposed to read it. Now, please come to chapter 5. Now, thus far, your lordships were examining sections under the heading composition of the tribunal, with which we are concerned. दोनों साइड
We will finish by 1 o'clock.
My lord, Lordships would agree on 2 points. We started little late.
No sooner.
I started, my lord, further late, my lord, I was answering. And this happens, my lord, when you are on the, to come to bat, my lord, after the first inning. And, my lord, I have not been repetitive or irrelevant, my lord.
Roughly how long?
Not more than, my lord, half an hour.
Try and sort of compress it as much as we can within half an hour.
I'll try.
We are trying to lay down.
Relevance.
Yes, my lord. My lord, please come to, my lord, chapter, I'm sorry.
You have been highlighting the principle of party autonomy which runs through the entirety of the act. That's what you're saying.
Yes, and, Lord, I'm also dealing with their submissions, my lord, which are made in my respectful submission out of context. That's what, my lord, I'm trying to show by saying that one chapter, composition of tribunal is over. Now, my lord, chapter 5, conduct of arbitral proceedings. So the tribunal is constituted, whether it's a sole arbitrator or a multi-member tribunal. Now, how the conduct will take place, please come to 18, my lords. Section 18. Equal treatment of parties, your lordship, my lord. My lord, my lord.
Yes.
Equal treatment of parties, the parties shall be treated with equality. By whom? By the arbitrator. Because it is in the chapter of conduct of arbitral proceedings. And it next line, my lord, strengthens the interpretation, my lord, I am respectfully giving. The parties shall be treated with equality and each party shall be given full opportunity to present his case. By whom? By the arbitrator. This does not talk of equality in terms of the contract under 11.2. This is before the arbitrator. The tribunal is constituted and now proceedings are going on.
Here, the argument of the other side was that the conduct of the arbitral proceeding would also include the appointment and composition of the arbitral proceeding, the arbitral panel.
Yes, sir. I'm
And that is
mindful of that.
I'm sure that you are trying to address that.
Yes.
Which was argued yesterday.
Yes, Manoj. Because composition is a separate chapter providing for every step of composition. Conduct has a separate chapter providing for every step in conduct. And unless, my lord, we give that meaning, my lord, how would we reconcile 18? The parties shall be treated with equality. By whom? By the arbitrator, and it gets strengthened, and each party shall be given a full opportunity to present his case. By whom? Obviously, during the conduct of arbitral proceedings, by the arbitrator.
Followed by 19, which lays down the
This equality is not equality of entering into an agreement under 11.2.
This is the manner we also read it,
Yes.
as we read yesterday, because it is immediately followed by 19, which talks about the procedure. And that will be governed by the arbitral. But the argument is that no, even at the stage of appointment, this equality principle should come.
But treated equally by whom? We are two parties. We can't treat each other equally. We can contract that one will not be equal to the other. It's an act of volition. It's purely in a private domain, private law. When it says giving an opportunity of hearing, my lord, would we give opportunity of hearing to each other? When it is, my lord, under the heading conduct of arbitral proceeding with a mandate that everyone will be heard, means by the tribunal. There cannot be, my lord, with profound respect, any other meaning given to it. To come out of this argument, my lord, the reliance is placed on 21. Now please come to 21. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent. The argument is that it is only after this notice, arbitration notice, that the tribunal is constituted. And therefore,
Yes.
18 should be read as
Commencement.
commencement. Lord, why this section 21 is placed in this chapter? Not to ensure that the entire chapter applies to the initial appointment of initial contract, which would determine the method of appointment of arbitrator. Please come to Malord 23. Within a period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts when the claim will be made. Malord, there has to be a beginning of time, Malord, when the proceedings continue, proceedings start, that from the date of the notice, within 5 months, you must file your statement of claims because the object of the act is expeditious disposal. 21 is in this chapter only to ensure that parties can use that date as a starting date for filing statement of claim, filing defense, filing documents, etc., etc.
Earlier, under 40 Act, commencement was declared to be from the time when an arbitrator enters reference.
Correct, my lords.
That they have deliberately changed it. to-
Yes, my lord. But my lord, even 21, my lord, please come to 21 again. I'm obliged, my lords. But please come to 21 again, my lord, on my request. Unless otherwise agreed by the parties.
It's a derogable provision.
Yes, so we can say that the date of commencement would be the first meeting of the arbitral tribunal. This is why it is housed in the chapter which provides for conduct of arbitral proceedings. Lord, one more I missed, my lord. I'm obliged to my learned friend.
This procedure will be subject to.
Lord, I'm obliged to my learned friends. My lord, I missed section 19, which furthers my, my lord, respectful interpretation of 18. Please see, my lord, 19. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in the manner it considers appropriate. So 18 is during the conduct of arbitral proceedings. And 19 presupposes that there already a arbitral tribunal in existence. It is constituted under chapter 2. Now, my lord, please see the first line.
Really would stretched to its logical conclusion mean that the requirement of equality under section 18 would override even an agreed procedure.
Agreed procedure, and my lord, it would make the second part of 18 redundant, that parties will be given full opportunity of hearing. By whom?
Yeah, okay.
It can't be by each other, that I will hear him and he will hear me.
The relationship is governed by agreement,
11
but the conduct of arbitrator must be equal.
equal.
If it doesn't, then 34 comes in saying that you would not. And it is,
Suppose, my lord, there is an arbitral agreement that they would not have a right of defense except on ABCD grounds. Then 18 kicks in. Then the tribunal is bound to treat both equally and give them full opportunity. Suppose there is an agreement that they will not be heard. Lord, 21 is housed in this chapter 5 because there is a provision for fast track arbitration agreement also. Parties can agree that now this would be the date. Date would be hypothetically the first meeting of the arbitral tribunal, and we agree that it would be over within 3 months. We put it on a fast track. Or this would be the date on which the arbitration has started, and we agree that within 1 month pleadings will be completed. Therefore, to smoothen the conduct of arbitration proceedings, 21 is kept here. My lord, just quickly, 25, just first line, just to show, my lord, party autonomy is, my lord, writ large. It runs through the architecture of this act. Default of a party, unless otherwise agreed by the parties, this can be done. Then 26, unless otherwise agreed by the parties, the tribunal may appoint so and so. So parties are free to choose what they are contracting, what is their commercial bargain. Now, Lord, sometimes your lordships do something to achieve the ends of justice in a 226 jurisdiction, which arbitral tribunal also can be conferred with. Please come to section 28, subsection 2. This also is dependent upon the parties agreeing to confer their jurisdiction. The title is Rules Applicable to Substance of Dispute, but relevant, my lord, is 2, subsection 2. The arbitral tribunal shall decide ex equo et bono or amiable compositure only if the parties have expressly authorized it to do so. Otherwise, arbitral tribunal is bound by the terms of the contract. Now, your lordship, my lord, kindly come to 34. May I continue, my lord?
We'll come back after. So we'll ask.
Try.
Bench, we will, after the solicitor concludes, in the list which is given to us, we'll first hear counsel appearing for the parties. Then whatever time we are left, we'll give a little time to, the interveners. So we have Mr. Nataraj for core, Mr. Arvind Kamath for BMRCL. Then we have Guru in Sundaram Finance, Ms. Madhvi Diwan for Mahindra Mahindra. Then we have Anand Padmanabhan for the petitioner in Equitas. And we have Suman Doval for the respondent in Nilcon. We'll give a little time to each one, and then whatever time remains, we'll ration out between the interveners and wrap it up today in the afternoon. All right, 10 minutes, one counsel on your side. All right. Now 10.
This is not derogable. Time is non-derogable.
I am appearing for Tata Motor Finance. My application is minutes filed.